Corporate sponsorship for this webinar is provided by Alkalock, North Carolina's preferred provider of ignition interlock technology. Alkalock devices are designed to prevent drunk driving offenses, and in 2020 prevented over 25,000 vehicle starts when alcohol was detected. Alkalock is proud to support ongoing education for law enforcement to help divert the consequences of drinking and drugged driving, and to support all traffic safety professionals dedicated to keeping North Carolina's roads safe for our neighbors and communities. For more information, visit alkalockusa.com. Welcome to this traffic safety webinar sponsored by the North Carolina Governor's Highway Safety Program. This is one in a series of webinars addressing topics of interest for traffic safety professionals. The series is co-hosted by the Institute for Transportation Research and Education at NC State University and the University of North Carolina Highway Safety Research Center. Today's topic is DWI checking stations, how to get them right, presented by Master Trooper Joseph Byrd with the North Carolina State Highway Patrol and Justin Philbeck with the North Carolina Conference of District Attorneys. Joe Byrd is a Master Trooper with the State Highway Patrol and has over 21 years of law enforcement experience. He is a certified drug recognition expert instructor, a certified chemical analyst by the North Carolina Department of Public Health, and is certified in traffic crash reconstruction. He has qualified as an expert witness 64 times to date on DWI and DRE related cases in both district and superior courts. Joe teaches several courses for the Highway Patrol and the North Carolina Community College system, including NHTSA DWI detection and field sobriety testing, basic crash investigation, and techniques for traffic law enforcement. He also teaches officers and prosecutors throughout the state as an instructor with the North Carolina Conference of District Attorneys. Joe is a United States Marine Corps veteran and formerly served as an officer with the Charlotte-Mecklenburg Police Department, and he holds a Master of Science degree in Criminal Justice from Liberty University. His co-presenter, Justin Philbeck, is a regional traffic safety resource prosecutor with the North Carolina Conference of District Attorneys. Justin joined the department in 2017. He's based in Asheville and serves the state's western region. Justin conducts training for prosecutors and law enforcement, provides technical assistance for complex issues that commonly arise in DWI prosecutions, and handles conflict DWI prosecutions for local DA offices in his region. Justin previously worked as an assistant DA in North Carolina, serving Watauga and Avery counties, and is a graduate of the Wake Forest Law School. Joe and Justin, if you'll please turn on your cameras, share your screens, and begin your presentation.
Thanks very much, Eugene. Appreciate it. Hi, everybody. I'm Justin. I'm going to keep my camera off for this. I've had bandwidth issues in the past with slowing down the presentation, so you'll just hear my voice today. And with me is Joe Byrd. Hey, Joe, how you doing?
Hey, I appreciate everyone being here today. Thanks, Eugene, for the intro. Hopefully we can answer some questions and shed some light on the basics of checking stations here in North Carolina.
Yeah, so let's get right into it. So here's our basic objectives for this presentation. We're going to go over 20-16.3A checking stations and roadblocks, 20-16.3A being the North Carolina statute governing checking stations. And we're going to go over some of the topics within that: choosing a location, writing the checking station plan, operating the checking station, and after action reports. So
go ahead. I'm sorry, Justin.
No, you're fine, Joe. Go ahead.
Basically, 16.3, the statute that Justin just referenced, will be the basic outline of the time we are together as far as the checkpoint procedures of law. The statute in Chapter 20 is very clear and specific on checking stations. And just as a general rule of thumb, as a prosecutor or as a law enforcement officer that's involved with these things, you know, if you'll just refer to that statute, it'll pretty much outline everything that you need to do to conduct a successful checking station here in North Carolina. But we all know they're a valuable tool for law enforcement to help enforce traffic laws and improve community relations. And we want to always remember that the objective of checking stations is to reduce the number of vehicle crashes, injuries, and deaths contributed to impaired driving offenses. And our main purpose as law enforcement officers and prosecutors, as well as partners, is protect lives and property. So that's our main focus here and what we're here to do. So we'll keep that in sight as we go through this presentation.
And so one of the things that, it kind of shocks people when you first get into criminal law, if you're law enforcement or if you're a prosecutor and you get into these DWIs, these checking stations, and you think about, well, why are these things examined so closely? But there's actually a pretty good reason for it. The Fourth Amendment requires every stop procedure to be reasonable. The touchstone of the Fourth Amendment of our Constitution is that you cannot have an unreasonable search and seizure. That means that most stops must be based on some kind of reasonable, articulable suspicion of criminal activity. But a checking station allows for stops without any reason other than just someone's driving on the road. And so the Supreme Court, looking through the lens of the Fourth Amendment, takes very careful concern, it takes a lot of concern toward these kind of suspicionless, quote unquote, stops at checking stations. So they really have to pass a considerably high bar to justify a completely suspicionless stop. So that's why these things are considered and examined as closely as they are, and why we tend to have hearings in court on these things for hours, and why law enforcement has to provide so much paperwork, because the Constitution of our country really does not like suspicionless stops. So we have to have a pretty big justification for this.
All right, just a couple basics. As I mentioned earlier, the basis of the whole class will be General Statute 20-16.3A. Checking stations and roadblocks is how the statute is entitled. When we talk about checking stations, we're going to refer to this in the future here in a few minutes, but just know that there's only one type of checking station for Chapter 20 violations, and this became effective on December 1, 2006. Those of us that were in law enforcement prior to December 1, 06 probably can think back and remember prior to that date, there were more. There was actually a specific DWI checking station, namely, and then there was regular checking stations or roadblocks. The statute, the legislator came together around that time period and said, let's just simplify this, make there one technical checking station, and that alleviated a lot of the, namely with the DWI checkpoints, a lot of the things that were written in the statute that we had the hurdles we had to get over as far as advertisement, notification of media, things like that, things of that nature. And in court, we were getting hemmed up a lot. There was some confusion out there with officers, prosecutors, and the DA was winning cases on a lot of technicalities as far as just naming and what we called them in court. Was this a DWI checking station? Was this just a regular checking station? So that was a good thing. December 1, 06, the legislature came together and they simplified it for us. So that's what we'll be going over through the bullet points of the statute today.
And so the very first subsection of 20-16.3A, a law enforcement agency may conduct checking stations to determine compliance with the provisions of this chapter. So that's the very first line of the statute, and it's significant because it's telling you, it's making the declarative statement that Joe just made. A law enforcement agency may conduct checking stations to determine compliance with the provisions of this chapter, being Chapter 20, which means it covers DWI, license, registration, any kind of other traffic things, open containers, stuff like that. The purpose of a checking station conducted under this statute is to determine compliance with Chapter 20. There's no distinction between enforcing any other part of Chapter 20 or anything like that. So that's the significance of that first line there.
All right, you'll hear us talk about this term a lot throughout this course, primary pragmatic purpose. Okay, you'll hear us use that term a lot. And basically what that means is that's, obviously the only purpose behind why we're doing a checking station. And there are a couple exceptions, but for the most part, if it's not a special operations or an information checking station, it's going to be to enforce Chapter 20. Okay, so it's going to be to ask for a driver's license and some other predetermined documents, whether it be a registration, insurance card, things of that nature. But at the very least, the primary purpose of us doing the checking station is we must not lose focus that it's for Chapter 20. All right, Chapter 20 violation. And to my traffic officers out there and to my prosecutors as well, you know, Chapter 20 is very vast. There's a lot of different statutes and infractions and things in Chapter 20 that officers can enforce through these checking stations. We've got on here that law enforcement officers are not authorized to establish a checking station to catch bad guys. You know, I know that goes without saying, but some of the things that we put these bullet points in here is because these are things that actually officers have actually said in court, believe it or not. They forget that the primary pragmatic purpose is for checking for Chapter 20. Officers, remember that this question on direct and cross-examination will be asked to you. So let's not lose sight of what that is. And you know, that's our primary focus. We've got in here, would you let a murderer go? We put that in there just because obviously, are you going to have drug cases that stem from these? Yes. Are you going to have other criminal Chapter 14 cases that stem from these? Obviously you are. So just no matter how the checking station goes or what crimes or what charges stem from these checking stations, just let's forget or lose sight that the primary purpose, pragmatic purpose for setting the checking station up was to check for Chapter 20 violations.
Yeah, absolutely. And I've never seen a hearing on a checking station in court where a defense attorney didn't try to confuse the officer about, you know, well, you would arrest somebody if you saw cocaine in their car, or you'd arrest somebody if you saw a dead body in their car. So really, you were out there just, you know, you were looking for crime. It was general crime enforcement. It's what you were doing, right? And, you know, it's true, obviously, if you see evidence of some other crime, you're obviously going to enforce the law. You don't stop being a law enforcement officer just because you're running a checking station. But the key, the way to answer that question is our purpose was to enforce Chapter 20. That's why we set the checking station up. But once I saw evidence of another crime, I wasn't going to ignore it. Of course, I was going to enforce that law. But the purpose of the checking station was to enforce Chapter 20. Yeah. And this is just some case law on the purpose of the checkpoint. The Burroughs case is about the idea that if the trial court, if there's no need to make an extensive inquiry about the purpose of the checkpoint, you don't have to make an extensive inquiry. It's only where the evidence comes into conflict with what the stated purpose is. So something like if an officer says, oh, we set this checking station up to do Chapter 20 enforcement, but then for some reason they're running drug dogs around every single car at the checking station, or they have like immigration agents or something going around asking everybody what their immigration status is at the checking station, or IRS people asking people about their taxes for whatever reason at a traffic checking station. That's the kind of thing where the evidence suddenly comes into conflict. Like, you don't need drug dogs to enforce Chapter 20, right? So why did you have drug dogs at the checking station? That's where it becomes an issue. But, you know, if officers are doing what they're supposed to do, if they're conducting a checking station, absolutely normal, asking people for license and registration, the average interaction with the vehicles, less than a few minutes, something like that, maybe less than 1 minute, if everything's in compliance. If that's going on, the court does not have to dive into all this and do some kind of extensive analysis on the purpose of the checkpoint. You can just say, okay, yeah, it's a legitimate purpose, let's move on. It's only where you have that weird contradictory evidence that the court has to have additional inquiry. That's something for prosecutors to be aware of. You know, I see people really get lost down the rabbit hole of this primary programmatic purpose thing, and you don't have to. There's case law that can help you there where it just says, listen, if the evidence was all running one way, the court can just say that's fine. I threw this slide in here as well because again, going to that thing where the defense attorney always wants to try and get at the officer. Prosecutors need to be objecting to those questions where the defense attorney is like, well, you would enforce all the crime in the world, wouldn't you? This quote, we caution that the purpose inquiry in this context is to be conducted only at the programmatic level. and is not an invitation to probe the minds of individual officers acting at the scene. I have this case with me and this quote highlighted every single checking station hearing I go to, because I know the defense attorney is going to be asking these questions, and I want to be able to object and put something in front of the judge that says, hey, he doesn't get to do that. He doesn't get to just go down here and ask all these ridiculous questions about what the officer would do if he saw dead body or cocaine or whatever. The officer said it was Chapter 20 enforcement, and everything they did at the checking station indicates that. And so, yeah, don't wait to argue that. Object to the question right up front. Have this quote with you.
And just to that point, you know, ADAs in the class too, you're going to know they're going to look, the court's going to look at reasonableness, right? That's what they always fall back on. And just know that, you know, on primary pragmatic purpose, that checking stations are going to look at as a two-part or two-pronged test. What was the primary pragmatic purpose? And if we can get in or establish that it was for checking for Chapter 20 violations based on the facts of the case and the evidence presented, we won't have any problem. The second one, the second prong would be they're going to ask, you know, is the purpose legitimate? And that's where we're going to get into reasonableness when we talk about some of the other checking stations that the Supreme Court have allowed us to do, namely informational checking stations and special operations or special circumstance checking stations, which we'll talk about here in a few slides. Going back to planning a checking station, this is the slide we're looking at right now. That prong 2, or excuse me, subset 2 of that statute says designate in advance, and notice I highlighted in advance and underlined there, the pattern for stopping vehicles and for requesting drivers that are stopped to produce driver's license, registration, or insurance information. So the reason that we underline that, these things aren't set up on a whim. All right, I know that happens. I've been a part of checking stations that were set up on a whim before. You know, it's not, we don't set these things up out of boredom because it's Sunday night. There's not a lot going on. You know, we're sitting around the Waffle House and, you know, hey, what do you want to do? Yeah, let's go check, you know, whatever, you know. Obviously they shouldn't transpire that way. They shouldn't originate that way. There needs to be some forethought in advance as to the pattern. Are we going to stop every vehicle? Or are we going to stop, you know, every other vehicle? And we'll talk about some contingencies that may arise here in a few slides. But I know the highway patrol policy, we've got to ask for a driver, at the very least, a driver's license and check for impairment, obviously, at the driver's side window, and one of 2 documents, which is on our HP14, which I'll talk to here in a few minutes, and I'll show you guys what that is. But we've got a place on there to check for vehicle registration or insurance, proof of insurance. So at the very least, we're checking for 2 things. All of these were obviously related to Chapter 20. So the point of this that I'm trying to make is that I know it kind of goes without saying, you think this is obvious, but you'd be surprised being in court. And I know some of your prosecutors have probably been caught off guard too with direct examination of your officers. Some of the answers you're getting is, you know, well, what was the plan as far as how many, you're going to stop every car, every other car, you know, whatever, you know, sure things that defense are going to attack, and the officer does not know, right? So again, it kind of goes without saying, but we need to make sure that this box is checked.
Yeah, absolutely. And another thing to consider for law enforcement out there, you know, part of the reason why your answers might not be as good as they would be at court as on the day that the checking station happened is, you know, when are we trying these cases? I mean, they're years down the road from when this date actually happened, when the checking station actually occurred. And oftentimes, you know, you might not keep notes on what the designated pattern was or what you were requesting from drivers if you're with an agency that isn't like the Highway Patrol and doesn't have its own pre-made form for this. So it's always a good idea to do some kind of documentation on whatever you did in advance of the checking station to plan for it. You know, did you decide we're going to stop every car? Did you say we're going to ask for driver's license, registration, and insurance information of every vehicle we stop? Just some kind of documentation to make sure you have that, because you're not going to remember 2 years down the road.
Yeah. Okay. So again, the statute talks about operating these checking stations under a written policy. I'll read it real quick and we'll go over it. Of course, you can read it. Just know that the policy need not be in writing. Your larger agencies, of course, Highway Patrol and these larger municipalities are going to have a pretty in-depth policy, I'm assuming, on checking stations and how to conduct business at these things. The statute specifically says the policy may either be the agency's own policy, or if the agency does not have a written policy, it may be the policy of another law enforcement agency, and may include contingency provisions for altering either pattern if actual traffic conditions are different from those anticipated. But, and this is underlined, no individual officer may be given discretion as to which vehicle is stopped, or of the vehicle stopped, which driver is requested to produce driver's license, registration, or insurance information. If officers of a law enforcement agency are operating under another agency's policy, it must be stated in writing. So, if you're a smaller agency or in a rural area or agency that does not have their own policy regarding checking stations, this right here says that you can use another agency's highway patrol, especially if you're doing a multi-agency checking station with our agency or another one, but you must, at least abide by what that is, and obviously be able to present that in court. Why this is important, we know this is 2021. I dare say almost every single one of these cases, the DWI that stems from this, or the drug seizure that stems from this, or whatever case stems from these checking stations is going to be on video, right? More than likely, whether it's a body cam or a dash cam or one of the patrol vehicles there. And, everybody in this class knows, what's the defense going to do once that discovery's been handed over. They're going to go through the video, and they're going to go through this statute and your policy, right? And if you've got any kind of written plan prior to that, and they're going to make sure all this stuff was adhered to. So, the moment that they watch 2 hours of video and see one car go by with 2 or 3 of the officers standing there smoking and joking and not even acknowledging that driver, you can bet they're going to ask questions about that, especially if it didn't adhere to, hey, we're stopping every vehicle or every other vehicle, or there wasn't some type of contingency going on. In other words, the 5 or 7 officers that were present were all busy issuing citations. Therefore, we let from 11:57 p.m. to 12:08 a.m. we let approximately 12 cars go through, or something of that nature. And that's important, and needs to be the job of the supervising officer. And we'll talk about who that is and what his duties are here in a minute. But that's why that's so important as well. So it's got to be, again, a little more than just, hey, we're going to set it up as a hunch. We'll go out there and just check licenses. If you've been a part of things like that, in the past, I know I have, just know that, hey guys, that we got to do this stuff right, especially nowadays in the era of video, because everything's going to be scrutinized and going over with a fine-tooth comb, and you guys know that. So,
yeah, absolutely. My take on this particular statute, especially that first sentence: operate under a written policy that provides guidelines for the pattern, which need not be in writing. Every time I've ever read that sentence, it is the most confusing thing in the world to me, because it says written policy, which need not be in writing, which is confusing. The way I've always interpreted this is that the agency must have a written policy of some kind. That policy that governs all checking stations, that needs to be in writing. The guidelines for the pattern, however, those are the things that need not be in writing, which I would interpret that to be like sort of the plan of,
yeah, we refer to that as the plan. You'll hear us talk about the plan. The plan is different from the policy, obviously, and that's what Justin's trying to make the point of. Your agency should have a policy, and probably everyone in this class today works for an agency who's got a policy. This day and age, I don't know of any agencies that don't have some kind of policy that addresses checking stations. But again, not to interrupt you, Justin, but he's exactly right. The HP14 is the Highway Patrol's version of the plan, which is a quick reference form that the troopers can take to court. And starting time, anytime, supervising officer, primary pragmatic purpose, why the location was chosen. And we'll talk about these things in a little bit. Was it statistically based? or was it random? Any contingencies that arose, things of that nature. It just gives the trooper kind of a quick reference in court to answer those questions. And one less thing he has to take notes on. But yeah, I didn't mean to interrupt you, Justin, but yeah, that's a good point.
Yeah, no, you're fine. That's good insight on that. I just wanted to point that out because I think this sentence is one of the most poorly drafted laws I've ever seen, just because it's so confusing. But yeah, the plan versus policy is one of those things that I get a ton of questions about from prosecutors all the time. A written policy, that's just a big, thick policy that governs all checking stations that's in some captain's drawer somewhere at the station. It's written somewhere, but it's not something that you have to break out for every single checking station. It's just something it needs to exist. Whereas the guidelines for the pattern, which is the plan for this particular checking station on this particular date, that does not need to be in writing. Obviously, for the Highway Patrol, they use HP14, so all of their plans are also in writing, but you might have an agency that has a policy written down somewhere, but all of their checking stations are just, we meet up at some place and we talk about what we're going to do, and then we go out and handle the checking station. And that is fine per the statute, as long as it's just that agency working its own checking station. If you skip down to the very last sentence, though, if officers of a law enforcement agency are operating under another agency's policy, it must be stated in writing. That's something that a lot of people miss in the statute, and it causes issues when you have, say, a couple of highway patrolmen and then some local sheriff's deputies and maybe a city agent comes out to help as well. You just kind of have, law enforcement's out there just trying to help out each other, doing some license checks. But then, if nobody really writes down whose policy are we operating under, it causes an issue for the statute. So just be aware of that. The highway patrolman, this is actually why I prefer to have all plans written as well, so that you can specifically put in whose policy you're operating under if multiple agencies are at that checking station. The HP14 has a great little place for it where you can just put all the agencies that are attending, and I think that satisfies the statute.
Yeah, and another thing defense attorneys like to attack too, I'm sure with a class this size, there's some folks in here officer-wise that are involved or a member of some kind of DWI task force. And I know there's some prosecutors here that are prosecuting cases from DWI task force. There are several of them throughout the state. Just know that too, that's going to be a possible way of defense tries to trip these guys up. And, if you're an officer in the class and you are on one of these teams, multi-agency teams, and it's a jurisdictional issue or something of that nature, just anticipate that. And, whoever your supervisor is, which I know they already have already, I'm sure you guys are squared away, but just make sure and anticipate that that's going to be attacked, whether it be a jurisdictional thing or, you're with the highway patrol, you're on a task force with deputies and police officers within this one county, which agency's policy are you guys working under? So just anticipate those type of questions. And there's a copy. I apologize for the quality there, but I put those on there. That's just because that's the highway patrol, both policy and what we refer to as HP14, which is our version of the plan. As you can see, that this policy is multiple pages long, but that's just the first page of it. But if anyone would like copies of this, our emails at the end, we can hook you up with this. But the HP14 is cool. We're one of the few agencies I know that do something like this. And again, like I said before, it's kind of just a quick reference for the officer to have in court when he's got cases that are being tried that stem from a checking station. Pretty much any question that can be asked, he's got an answer for right here. So namely, when approximate start time, approximate end time, who the member in charge was, supervisor. We'll talk about that in a second. And if you'll notice that one up there, if you can read it, along with standard checking station, which was what that one was checked. And then it said at a minimum, checking each driver stop for a valid license and evidence of impairment. So that's what our policy says, checking for license and evidence of impairment. And then later on, if I was to scroll down the screen, there's also blocks on there to check if we're going to ask for anything additional, namely registration or insurance card or something of that nature. So just make sure this stuff's adhered to. And like Justin said earlier, these cases aren't going to be tried, a month after they happen. So you're looking at a year or 2 years down the road. So these kind of documents are invaluable to recollect the officer's memory.
And per the statute, the one on the left, the policy, is the one that needs to be written. The plan does not have to be written, but it's always a good idea to have a written plan. But that's what the statute requires. All right, so subsection 3, advise the public that an authorized checking station is being operated by having at minimum one law enforcement vehicle with its blue light in operation during the conducting of the checking station. Prosecutors, law enforcement, everybody, be aware of this. I have lost cases because the officer said emergency equipment, and I didn't think to ask what color the emergency equipment was. Blue has to be blue. The statute says blue. And so if a judge is looking to kick your case, they will kick it because you didn't say blue. The best thing I know to say on this is just, hey, have the statute out in front of you as you're trying a case, prosecutors, and just be aware that that statute says blue light. And if your officer, just listen to their answers. I know sometimes prosecutors have trouble actually listening to what the witnesses say from the stand. You're just nervous and trying to ask your questions. Make sure to listen to what your officer says. And if they don't say blue, prompt them, say that. What color was it? Was it blue? Something like that. Anything to say?
And also too, we all get in the habit of police jargon and what we call cop speak. And unfortunately we get complacent on the stand sometimes, especially you guys that are doing a lot of cases. And, prosecutors just, words matter, right? So, with questioning and things, don't let the officer get away with just saying, yeah, my lights were operational. That Ashworth case that we cite here at the bottom of that, I've heard Ike talk about that case for years. I don't know why it just stands out to me, because I thought it was kind of pretty crafty on the defense's part. But, just keep in mind, it's got to be at least one blue light. The cool thing is it's only got to be one blue light. So if I've got 5 patrol cars there, all of them don't have to have their blue lights activated, just one. The statute just says one blue light. Obviously, the supervisor is going to have to make that call as to the number that are activated, and officer safety and location and things of that nature should be paramount when making that decision. But yeah, one blue light's all that's required, but just make sure that the officers aren't just referring to the lights.
So a pattern designated.
Dean, are you there? I think I see somebody said there was a question. I'm not seeing that on my screen.
Oh, I see it. Does a mutual aid agreement or memorandum of understanding need to be in effect if an agency is participating in a checking station outside of their territorial jurisdiction and working under that agency's plan? We will actually get to that later in the presentation. We have some slides on mutual aid agreements. So we're going to get there.
Thank you, Justin and Jeff.
Good question. Yep. Great question.
So a pattern designated by law enforcement agency pursuant to this subsection shall not be based on a particular vehicle type, except the pattern may designate any type of commercial motor vehicle. And then we'll get to the second sentence there in a second, but basically the idea is you can't decide you're only going to enforce Chapter 20 against blue Hondas today or red trucks or something like that. You can't base the pattern on what type of vehicle you're going to stop. It's just, the standard way of designating a pattern is how many vehicles you're going to stop. Is it every third vehicle, every second, or every single vehicle that comes through? The second portion of this, the provisions of this subsection shall apply to this chapter only and are not to be construed to restrict any other type of checkpoint or roadblock which is lawful and meets the requirements of subsection C, which that's referring specifically to like an informational checking station where you're looking for information about a particular crime, or like a sort of a manhunt situation where that your perpetrator is driving a blue Honda, so you need to be looking for a blue Honda. That makes perfect sense. But obviously at those checking stations, you're not enforcing Chapter 20. You're looking for information, or you're trying to find a particular person. So that's the distinction of this particular statute.
Right. Also, too, and some of this was stemmed off of motorcycles coming from a specific area of the state where there was a rally. For whatever reason, there's been instances where officers maybe wanted to do checking stations that at least could be perceived targeting of a certain type of subset of the population who were specific in which vehicles they drove, right? So, obviously those things are going to be attacked. So we don't want to discriminate in any manner or way or form or fashion, at least by appearing to do that. So again, commercial motor vehicle officers with our agency, they don't have reasonable suspicion limitations as to far as stopping trucks and things of that nature. So that doesn't apply to that. But we're talking about just, the regular motoring public out here. So can't just stop motorcycles. We can't just stop Corvettes. We can't just stop RVs, right? Coming from the race or whatever, right? It's got to be every vehicle or whatever that, like Justin said, the pattern set forth.
So subsection B is really important, and I think it's one of the most overlooked parts of this statute. An officer who determines that there is reasonable suspicion that an occupant has violated a provision of this chapter or any other provision of law may detain the driver to further investigate in accordance with the law. So, your purpose of your checking station is to enforce Chapter 20, but if you have reasonable suspicion, which is a pretty low bar, that they have violated a provision of this chapter, Chapter 20, or any other provision of law. So if they reasonable suspicion of any crime whatsoever, you can detain the driver to further investigate in accordance with law. So if you're in a situation where you're in court and you're wondering, the defense attorney's saying you can't pull me out of this car because you had evidence of larceny or something like that, you absolutely can. This is the statute that says so right here, subsection B of 20-16.3A. The operator of any vehicle stopped at a checking station established under this subsection may be requested to submit to an alcohol screening test under 20-16.3, which is the PBT statute, if during the course of the stop, the officer determines that the driver had previously consumed alcohol or has an open container of an alcoholic beverage in the vehicle. So you're good to go for the PBT if you figure out the person has previously consumed alcohol. They might admit to it. Maybe they smell like alcohol, something like that. Or if you see an open container in the vehicle, that's your green light for PBT right there. And then the officer so requesting shall consider the results of any alcohol screening test or the driver's refusal in determining if there is reasonable suspicion to investigate further. So sometimes I'll get questions from prosecutors or even law enforcement saying like, hey, I had some defense attorney the other day say that, they refused the PBT at a checking station, but you can't consider that because, 20-16.3, the PBT statute doesn't say anything about that. So where's that at? Here it is right here. It's the last sentence of subsection B. If the officer, if you request it and they give you a screen, or you give them a PBT and they refuse, you absolutely can use that as reasonable suspicion to investigate further.
Correct. Absolutely. Okay, we talked about a couple of things. We talked about the primary pragmatic purpose for just a normal checking station, so to speak. I hate to use that word. None of them are really normal, but is for the check for Chapter 20 violations. Obviously, you know that there are other circumstances that would warrant law enforcement to seize a motoring public or the motoring public for different reasons. One of it being an informational checking station and special operations checking station. This is where subset C comes in. It says the law enforcement agencies may conduct any type of checking station or roadblock, again, as long as it is established and operated in accordance with the provisions of the U.S. Constitution and the Constitution of North Carolina. There's that reasonableness standard that they're going to ask, was it reasonable, whatever reason. If it was a bank robbery, like Justin said, they're looking for a specific vehicle. If it was a missing person type thing, a bolo sent out on a bank robbery or whatever. Obviously, we're going to have a lot more specific information into those things, and the court is just going to look, location, time, things like that. Was it reasonable? So that, things of that nature haven't historically been too hard to prove.
And so there's some examples of some other purposes that you might have for setting up one of these alternative checking stations. You're looking for a specific criminal, or you're looking for information about a missing child or something like that. These are both totally appropriate reasons for setting up a checking station. And there's law from the U.S. Supreme Court as well as North Carolina courts that these are lawful purposes for setting up a checking station. And the unfortunate reality is that you set up a checking station for one of these purposes, sometimes you might catch a drunk driver out of one of those just because you're interacting with people at the road. You know, the officer, you can't just ignore when you smell that alcohol. You got to conduct your investigation. You got to enforce the law as you normally would, especially when you're talking about something as serious as drunk driving. And so, you know, your case is not sunk just because you have a DWI come out of one of these informational checking stations or something like that. Those are lawful checking stations, and officers don't have to simply ignore violations of the law just because that's not the purpose the checking station was set up for. Just be ready to argue about it in court because it's going to come up. And here's the U.S. Supreme Court case on that, the Lidster case. Officers may conduct informational checking stations for the purpose of seeking motorist assistance in solving crime. You obviously, when you do this kind of checking station, you're not checking every single vehicle and asking for driver's license or any other documentation because that's not the purpose. You're looking for information about the crime and that's it. But obviously, if you determine that there's reasonable suspicion to believe that the vehicle occupant has violated Chapter 20 or any other provision of law, you can detain them for further investigation. That is totally fine. You know, it's not that you have to ignore criminal violations or anything. It's just that you can't be actively checking for license and registration, quote unquote, enforcing Chapter 20 if that's not the purpose of the checking station. So you want to
go ahead, Joe? I'm sorry. Did you have anything else on that as far as before we move on as far as to location?
Yeah, this is actually one of my favorite subsections of the statute here. The placement of checkpoints should be random or statistically indicated, and agencies shall avoid placing checkpoints repeatedly in the same location of proximity. This subsection shall not be grounds for a motion to suppress or defense to any offense arising out of the operation of a checking station. You should never lose a case based on subsection D because the subsection itself specifically says this can't be grounds for a motion to suppress or a defense. So if you're losing cases because of where you're setting up checking stations, like the location issue, that should not be a problem. Obviously, you should be doing it randomly. It should be statistically indicated, and you should avoid putting a checkpoint right down the road from the local bar where all the drunks leave at 2 a.m. every morning or whatever. You don't want to do that every Saturday night, but technically the statute says it's not a grounds for motion to suppress. So if you do it and they try to complain about it, they don't really have a leg to stand on. And there's a lot of case law on this. I recently had a case where troopers actually were moving their checkpoint. They would set up a checkpoint and then I don't know if anyone's familiar with the Waze app, but basically it's like Google Maps or any other map app, except that users can actually put in information, like they can flag stuff like officer checking stations. And they would flag the checking station, and officers had the Waze app up, and every time their checking station got flagged, they would move the location to somewhere else so they could stay ahead of where the Waze app was flagging people for their checking stations. They could keep catching people unawares. And the defense kind of argued a bunch of stuff related to subsection D, and the court at trial said, no, we're absolutely not. It says it's not a ground for a motion to suppress. We're not hearing this. They appealed it to the Court of Appeals, and the Court of Appeals agreed with me and said, no, subsection D says you can't make a motion to suppress based on this. It's not a defense. So yeah, this is a really good, it kind of begs the question why this is even in the statute if it has no enforcement mechanism, but you shouldn't be losing cases based on this.
Yeah, just for the officers that are attending, like I said, man, if you're using HP14 or some plan form that you've got, you're going to have some kind of checkbox stating, whether it was random or statistically indicated. And if a DWI comes out of it, you're going to be doing a detailed report based off copious notes. And I'm sure that you're going to have this indicated. If you've got stats, actual printed out stats of that location from, comp stats or whatever from the year prior or whatever, how y'all came to the conclusion of doing it there, those are great. I've seen that in court. I've seen officers use those. Those look really good as far as choosing a location. That closes that argument up. But if it's random, man, it's random. Random's not hard to prove. Random's random. So, don't be afraid to have random checking stations either. I've also heard statistically indicated checking stations, or the officer testified to those. He didn't necessarily have anything printed out, but he could testify under oath that he personally, had arrested, a dozen drunk drivers in that within a mile radius of that location in the last year, 18 months or something of that nature, where he can, prove it, and is based off statistics. But, don't be afraid to do random checking stations, because, these people that are out here violating motor vehicle statutes and DWI especially, obviously they're using all the roads out here. So they're not just using, your main roads either. So just one of those two things, as long as you have one of those two things, you can testify that how the location was chosen, man, you're good to go.
Yeah. And we kind of already talked about that. This is important, Joe. You want to talk about this a little bit?
Yeah. To my officers in the class, just know that, officer safety is paramount, just like anything else that we teach. And, none of this stuff's worth getting run over or getting killed over. When you're choosing your location, we don't want to have it, have the forethought to think that everybody comes through my checking station, where am I going to have either if I don't suspect impairment, the individual motorist to pull over, or, where are my officers going to take control of this vehicle when we ask the driver to exit, and where are we going to pull it off? Do we have a predetermined staging area for those suspected impaired drivers when we actually take them out and conduct standardized field sobriety? Do we have a location for that? What are the arguments that we can anticipate with that? Is it a reasonably hard, flat level, dry, flat level surface, right? Which, the NHTSA manual talks about as far as setting somewhat from doing administrative procedures on SFSTs. Is there a clear line of sight for motorists coming into the check-in station? We're not setting these things up in curves. We're not setting them up with big grades on the roadway, things of that nature. Just common sense. Seems like common sense stuff, but I have seen some locations picked that were very poorly picked, and some things, that could be questioned on, not only from a legal sense, but mainly from an officer safety standpoint. Officers and supervisors, especially supervising officers, just, be cognizant of that, and go through these checkoffs before you choose this location. Where we're going to put these people. Do we have a driveway? Do we have a parking lot nearby where we're going to store the cars until the wreckers come? If I've got a Batmobile involved, if there's a big enough checking station for that, we'll talk about Batmobile here in a few slides. But where am I going to take these folks? If it's a really big checking station, one of these multi-agencies where Mothers Against Drug Drivers come out, or the media is even out there, or whatever, right? You got to think about all this stuff and anticipate that. The slide talks about careful intersections. Think about the lanes that are out there. Ashworth talks about that as well as from case law. And again, patrol vehicles must be parked to allow access to the highway for pursuit in any direction. If you've got, you'll know this at the pre-briefing of the checking station, what hopefully is going on. But, if I've got multi-agencies there and some of them are allowed to chase and some of them aren't per their departmental policy, where am I placing these quote unquote chase vehicles? I know us with highway patrol, we get kind of touted to do those tasks a lot. The troopers here, we'll make them our chase vehicles, because a lot of the agencies anymore are not even chasing, whether they're allowed to or not. But just, all these locational things, you got to consider. You can't just throw this stuff together. And you guys know that, having conducted them before, but it's a lot to think of, and just make sure that we've covered all these bases before we get out there.
Yeah. And I'm going to be a broken record on this. I feel like I'm going to say this probably at least 3 or 4 more times, but an ounce of documentation here is worth a pound of gold in court. Again, 2 years down the road, you're not going to remember why you chose a particular area for the checking station unless you write it down somewhere. A sentence or two just explaining why that area was good for the checking station. You had prior issues there before. It was a good place as far as officer safety and motorist safety. There was an area to pull off for vehicles that were being taken in further investigation. Just anything you can write down to explain why the location was chosen. that's going to be huge in court. Just anything at all you can write down. So documentation.
And also photographs. Go back to slide 1, Justin.
Yep.
This bottom left picture, that's huge for court. You can present that as evidence, prosecutors, and it shows, hey, clearly they've got the traffic funneled into one lane. They've got a parking lot over here where they can do field sobriety. That picture right there, talking about a picture worth 1,000 words, that's really good, strong evidence for the prosecution. This one here, I think, of course, we got this off the internet, so I think that was kind of a parody or something. But we're not going to be putting, folks in a location, even motorists, even for their safety. Obviously, this isn't a safe situation for the officer nor the motorist. I think this is a picture from just a regular traffic stop anyway. But we put that on there kind of to make the point that, have the forethought that everybody that goes through there, you're going to ask them to get out if they're impaired. Hopefully, we're doing some kind of pre-arrest screening, standardized field sobriety test, and we're not doing this, right? So kind of goes without saying, but just keep this stuff in mind. And again, pictures, when it's done right, take as many pictures as you can. We'll talk about it in a few slides, but the Batmobile's out there, man, I want a picture of that. If I've got a line of sight coming into where the first possible point of perception to the check-in station, man, take a picture of that, okay? When you have a car turn around on you, and we'll talk about that here in a little bit too, you can actually show a picture, okay, this is what it looked like. This is what that motorist saw as he approached, within this many feet of the check-in station. So it just closes some of those arguments, some of those doors, where he can't get it there and say in court, well, I thought it was a collision scene, or I thought it was a wreck scene, or whatever, right? So yeah, just think about that stuff.
That's excellent advice. I would encourage everybody to follow that. I've never seen a checking station where an officer took pictures of the scene. That would be amazing. And this slide is actually exactly about the case I was talking about earlier. The Mackie case is my case. That was the one where the officers were moving the checking station around with the Waze app. And we won at the Court of Appeals. And this is a slide that Ike Avery actually put together, but he emailed me about this. This was my advice originally. If you're going to do something like that, if you're going to have a situation where you want to stay ahead of a Waze app, or you just generally want to move your checking station around through the night for whatever reason, my main point of advice would be plan the move in advance as best you can. If you're going to if you know for sure you're going to move to predetermined locations, talk about that in advance, include that as part of your plan, talk about your time, your location, and your reasons for moving, your reasons for choosing the other locations, that kind of thing. If you're not going to plan your specific locations in advance, if you're just going to kind of move whenever the Waze app pops up with your checking station, again, document that. Just document, at 9:45, I checked Waze app and Arch Station was flagged. So I decided to move from this location to X location because I thought it would be good, because we've had problems there in the past, because it was safe for motorists, safe for us, something like that. And, again, if you're going to stay there for a predetermined amount of time, document that. If you're just staying there until the Waze app suddenly pops up with that one, or whatever other reason, just document it. That's the key thing. That's the key point of this whole slide. Is just, if you're doing anything out of the ordinary, you're probably going to be okay in court if you just write down what you're doing. And if you don't write any kind of thing down, if you don't document at all what you're doing, that's where you're going to run into problems, because you're not going to remember 2 years down the road. Okay, so can the location be in a high crime area? Yeah, there's a case specifically on this point that I think is what the slide's about. The purpose of a checking station is to be Chapter 20 enforcement, but your reason for picking where that place is can have other considerations. So, if you put it in a high crime area, you want high visibility for law enforcement in that area because you think it'll have a deterrent effect, maybe settle down the neighborhood a little bit. That's fine, as long as you understand that the purpose of the checking station is Chapter 20, and you're not coming out there with like drug dogs, or you're not coming out there like looking for CIs to turn and get some information or something like that. The whole purpose of it is Chapter 20 enforcement. That's the key. you can have other considerations as long as you understand the purpose is Chapter 20 enforcement, and that's what you can articulate in court.
Yeah, the high crime area defense and things of that nature is just a sidetrack, them trying to go down a rabbit hole. Again, just like Justin said, officers, as long as you can testify to the primary pragmatic purpose, which we've established, you won't have any problems, with that. They're going to argue that all day long. Location's huge because, depending on what crime stemmed out of it or what charges stemmed out of it. But yeah, man, as long as the officers are firm on that primary pragmatic purpose, man, that's huge. They shouldn't have an issue with that.
Yeah. Okay, so, and this is the case I was talking about, the Harrison case. This is exactly what the Reedsville Police Department did there. They had a lot of violent crime in an area, and they decided they wanted to pick this particular area because of the violent crimes, shootings, and drug activity. That's where they wanted to set up the checking station. But the sergeant was able to specifically testify they were doing a license check for Chapter 20 violations, and they did it in accordance with Chapter 20 and 20-16.3a. And the court said, yeah, looking at the way the checking station was conducted, they didn't have drug dogs. They weren't asking a bunch of people about drug activity or, have you seen a robber lately or anything like that. They were enforcing Chapter 20 and they set it up and did it right. The court was like, yeah, this is fine. Of course, you can do a checking station in a high crime area and have that be on your mind. But if you're doing it to enforce Chapter 20 and you're conducting it in a manner to enforce Chapter 20, then that's perfectly acceptable.
Correct.
And so here is the mutual aid agreements. This is the fairly recent change. It happened a few years ago now, but basically what once was true is that you had to have specific rules, policies, or guidelines that allowed for mutual aid agreements. Now the statute specifically says unless specifically prohibited or limited by an ordinance. So whereas you used to have something affirmatively saying you can have mutual aid agreements, now the assumption is everybody's allowed to enter into mutual aid agreements, so it's much easier to do this if necessary. You can assist any agency can assist any other agency as long as they are requested to do so by the head of in writing by the head of the requesting agency. Anytime you see something in a statute that says in writing, that just basically means there needs to be a document somewhere that we can produce in court to say, hey, there was a mutual aid agreement. Here is the request from the head of the requesting agency for assistance and kind of like the nature and scope or whatever. We just need a piece of paper saying that this request was made. And so to go to Eric's question, which was, does a mutual aid agreement or memorandum of understanding need to be in effect if an agency is participating in a checking station outside of their territorial jurisdiction and working under that agency's plan? The answer is yes. You need to have a mutual aid agreement between law enforcement agencies if you're going to operate a checking station outside of your agency's traditional territorial jurisdiction. A mutual aid agreement will allow you to operate outside of that territorial jurisdiction and participate in that checking station. If you don't have that memorandum, that mutual aid agreement in place, you're going to run into issues in court. You're going to get arrests suppressed. Joe, you have any thoughts on mutual aid agreements?
Just, from an officer standpoint and having been a part of some kind of some of those circumstances with DWI task force and things like that, just anticipate that, in the pre-briefing, know that that's going to rise. That's going to get attacked, as far as jurisdictional things and stuff like that. That's just, defense, they're going to get paid a lot of money to try these things, especially these DWIs, and they're going to use that to muddy the water. So if you know that it can anticipate that argument going in, it's easily answered.
Yeah.
Good question. Good question.
Mm-hmm. Looks like another question. Let's see if it's related to this. Does the mutual aid agreement have to list individual officers assigned to the event? No, it does not. What I would say is all it has to be is the head of one agency asking another agency for assistance. It doesn't have to say specifically which officers are going to be involved. I think you're covered as long as you're just saying, Buncombe County Sheriff's Office will be assisting with North Carolina State Highway Patrol at this agency. You know, that's all that need to be said. The only time I would say you need to list specific officers in any of this is if you have a situation where some officers, like sheriff's deputy was bad choice there because they have jurisdiction all over Buncombe County, Asheville Police Department, say. The only time I think you would need to list specific officers is if you're talking about a less formal situation where like officers just kind of show up to a checking station to assist without a mutual aid agreement in place, but there's still good territorial jurisdiction there. I would be more comfortable if the plan sort of listed these officers assisted us in this, and that covers you for as far as 20-16.3A. But when it comes to mutual aid agreements, no, specific officers do not need to be listed in that, in my opinion.
Yeah. James Murray, you there? James, how you doing, James? He's got a question here in regards to the blue lights. Can they be on steady glow? He's got in quotation cruise lights, or do they have to be flashing? It's a good question. The statute says blue lights in operation. So, James, if you want to be the first one to make a case law on that. That's a good question, man. I mean, like I said, man, I just read it from the statute. It says blue lights in operation. So I'm not sure what you mean by glow cruise lights or what your car has, but I said, man, as long as they're blue, what do you think, Justin?
Yeah, I typed him out an answer earlier. I said basically what you just said is the statute's not that specific, but as long as you can testify that they were activated, I think you're fine. Like whether they're flashing or steady glowing, I don't think that's a major distinction.
Right. Yeah, it doesn't specifically say flashing. So this says in operation. So I think you're good.
Yeah. So what if I cannot prove operating under a mutual aid agreement? What if you got a situation where there is no mutual aid agreement? You got an officer working a checking station outside of their territorial jurisdiction. There are arguments you can make. Basically, it is not fundamentally unfair nor prejudicial to a defendant that evidence is obtained by a police officer outside of their territorial jurisdiction. That's the Philbeck case, and there's a couple other cases you can read there. It's an argument you can make that, you know, this is fine. It's really not that big a deal. It shouldn't be suppressed. But I feel like you're kind of fighting an uphill battle there, prosecutors, if you find yourself in this situation. The best thing to do is not find yourself in this situation to begin with. So if officers do come to you saying like, hey, you know, our policies are kind of like this as far as doing a checking station, but sometimes we just show up and help each other. Just make sure you educate your officers like, hey, you need a specific mutual aid agreement in place if you're going to operate outside of your territorial jurisdiction. Just make sure your officers know about that.
Are we caught up with all the questions? Dan Cutler asked a question, or made a comment.
We're caught up, Jim.
Gotcha. Good deal. Okay, cool. I missed that. You were correct, Dan, on your comment. That is correct. Okay. All right, let's talk about the pre-briefing. We've been talking about this. Obviously, we don't want to set these things up on a whim. Hopefully, we're having some kind of pre-briefing with the supervising officer. Note that we keep referring to the supervising officer checking station. Just note that doesn't have to necessarily be a supervisor, a sergeant, a corporal, or a lieutenant, or anything like that. It can be a regular, you know, I say regular, it could be a trooper. Doesn't have to be a person by that agency as far as a supervisor, anybody with rank on their sleeve. Just have to be somebody named as the supervisor of that specific check station. Some of the things we want to go over, obviously the operational policy and plan. We kind of went over that ad nauseum earlier as far as know what the policy is, review it, read it. If you're the supervising officer, it might not be a bad idea to print that out, give that to all the members involved in that checking station, and what the plan is. You know, with us, the HP14 information, you know, starting time, ending time, who the supervisor is, location, why was the location chosen? Was it statistically based or random? You know, things of that nature. What are we specifically going to be asking for? Are we stopping every car, every other car? What's the contingency going to be when, you know, we've got 5 officers in the checking station and all of them are busy doing enforcement, citations, doing SFSTs, you know, one of them has to run to the bathroom, you know, whatever, right? That's what that supervising officer is there for, not just necessarily be out there checking with them, checking license with them, but he needs to be someone who can answer all these questions and fill out this after action report. Equipment to be used, obviously we want, reflectorized vest, lights, that's going to have to be your call. We talked about earlier, the statute only requires one set of blue lights in operation. Obviously we want uniformed officers out there. Uniforms are going to come into play from the defense standpoint when, we're out here and we're testifying that the primary pragmatic purpose was checking for Chapter 20 violations, but I've got video that was presented as evidence, and everybody there conducting the checking station were in full fatigue, tack vest, SWAT, MOP level 5, whatever, right? Some other type of uniform where they can kind of go down that rabbit hole. So just be aware of appearances and uniform things. Alcohol screening test use, if you're going to use those, just make sure their last, the guys are up to date on when they were checked for accuracy, their calibrations, things of that nature. Just anything the defense could ask. If you've got DREs present, their certifications up to date, guys, when was their last SFST refresher, things of that nature. How detailed this pre-plan or pre-brief is totally up to the supervisor, but I can tell you the more detailed and the more extensive it is, the better successful outcome, at least when it comes to court, when these cases go to court, like I said, 2 years later. So a lot of that's common sense, but just don't overlook that to get with them and go over these things with all your members. Some other things, I mentioned earlier, where we're going to put these folks that we suspect that are impaired, whether it be alcohol or drugs, do we have a relatively hard flat level service that we're going to take them, whether we have a line for walk and turn or not, where are we going to take them somewhere safe that's not off to the side? Is it a parking lot? Is it the side of the road? Do we have those locations? Apprehension vehicles, that's what I referred to earlier as the chase cars. Are we going to have those? Are we going to have, individuals at this checking station who that's going to be their primary job? If we've got turnarounds or suspected turnarounds, are they going to, be pursuit vehicles or what they call apprehension vehicles? Arrests, citations, talk about that. We're going to be doing e-citation, handwriting tickets. All these things have to be taken into consideration. Folks that we're going to go 1072 with or arrest, do we have good locations for that? Do I have the Batmobile there? Am I going to take them in there? That changes the game too. This one's important, especially with the multi-agency checking stations where you got guys there from different agencies. Know who's got body worn cameras, right? So just take note of that. Obviously, that's something we want to know. Who's got in-car cameras? When do they work? What's the procedures on those? Are they going to be running the whole time? These are decisions that you're going to have to make and at least take note of. And again, officer in charge. It doesn't have to be necessarily a sergeant, corporal, or someone the agency deems as a supervisor, but someone has to be designated in that pre-briefing as the supervisor of that checking station. We went over that stuff, as far as SFST refresher. Make sure that if you're using PBTs, preliminary breath test devices out there, they've been calibrated within the last 30 days. Explain the plan to them, okay? And talk about it. Talk about law. If there's been any new case law come up on checking stations or anything like that, unusual circumstances, any things that officers that are present have experienced in court that come up, share those things with the other members that are there. And just, again, you can't have enough knowledge. I've got on here, this is an older one, but, hey, what's the latest revision date that NHTSA's putting out on the SFST manual, February 2018 or whatever it is, right? Make sure that the guys know that, and so they can take note of that and put it in their notes, because these are just possible questions that they could get challenged on.
So dogs at checking stations comes up quite a lot because dogs at checking stations are kind of one of the key things that courts look at to be particularly concerned about whether or not there's going to be an unlawful purpose, because there are a couple of cases out there where officers use dogs at checking stations, and they were basically running the dogs around every single car that came through, and you just can't do that. That indicates that we're not really here to enforce Chapter 20. We're really kind of doing a more general crime deterrence sort of concept. But that doesn't mean that you can't have dogs at any checking station at all, ever. It doesn't mean or if there is a dog that's in use at some point, that means the checking station is invalid, period. And that's what the Branch case is about. There was a checking station where a dog alerted on drugs while the validity of the driver's license was being checked. There was no additional delay. One of the big issues with using dogs at checking stations is people get stopped, and while they're, the Chapter 20 enforcement portion is already done, but the officers will keep them there and say, wait, we got to get the drug dog around your car first, then you can go. And so that creates that additional delay. Whereas here in this case, there was no additional delay, and the delay for the license check was reasonable based on the officer's knowledge of the defendant. I'm not terribly familiar with the specific facts of that case. I'm not sure what that means exactly. Maybe the officer knew this particular defendant was a known drug trafficker of some kind. Or maybe he just knew that the person had a whole lot of traffic tickets, and there were going to be some issues with their license or registration or something. And the court declined to say there was some heightened suspicion requirement for using the dog in that situation. That was okay. And then here in State v. Smith, this is probably a more common situation. Let's say you have a couple officers at a checking station, and one of them happens to have a canine unit. Well, that doesn't necessarily mean your checking station is bad. That doesn't immediately mean it has to get thrown out. It just, law enforcement agents or officers with canine units, they are also going to be at checking stations sometimes. And so if the dog's just there, if it's just waiting in the car, or it's just with the officer, but they're not running it around every single vehicle or anything, then that's really not a problem. And the court in State v. Smith has said, yeah, that's fine. Just its existence, the dog being there, doesn't make it an unlawful checking station. It has to be part of the regular use, and it has to be indicative of a more general crime deterrence purpose. And that's clearly not the situation in State v. Smith. But then you have the Burroughs case where 4 of the officers were drug agents and one had his dog with him. And if I remember correctly, in that case, that's the one where they were running dogs around every single car. And I think all 4 of the officers who were drug agents were also walking up to every vehicle with flashlights, kind of flashing in the back seats, looking around and everything. It gave the court a lot of reason to think, maybe there's some other purpose here besides just Chapter 20 enforcement. So that's what you're worried about right there. But don't think that you can't ever have dogs at a checking station. Just be very careful about how they're being used.
Joe and Justin, we did have a follow-up question with regard to statute and in Q&A and mutual aid and static versus roving checking station.
Okay, so I'm seeing in New Bern PD, we conducted a checking station that was split, 2 hours static, 2 hours roving. The DWI was thrown out due to the defense claiming split checking station was not consistent with statute. We disagree. Please advise mutual aid was in place. I think we need a little more information on this one Yeah,
what do you mean by roving? Do you mean that it was moved to one stationary location was moved to a second stationary location? When you say roving, can you specify with that, please?
Mm-hmm. Yes, sir. We'll do a static checking station as most normal ones. We're just all sitting out there, but we've hit Waze so much in Google Maps and all that we've started doing basically a patrolled area. So we'll be 5 or 6 blocks within the original checking station, or we may move to an entirely different part of the city, but all the available officers are roving in their cars, and we're just enforcing all Chapter 20 violations or whatever the checking station plan tells us to do. So of course we got a DWI off of it, off a vehicle stop with just the Chapter 20 violation, which ended up being a DWI. And it got thrown out basically because no one, I guess, had ever seen that before. So,
and so, if I understand correctly, you're saying that basically this turned from a static checking station to sort of a saturation patrol. Is that kind of the?
Yes, sir.
Yeah, and the vehicle that was stopped, it was stopped for a Chapter 20 violation.
Yes, sir.
Yeah, that you're done with the checking station. Once that you guys broke up that static checking station and became a saturation patrol or area patrol or whatever you want to call it, as long as you had a good stop, I mean, that should have been a good arrest, because that's all this checking station stuff ended once you guys went mobile.
Okay, so I think where the issue came in was the mutual aid expired once we ended that 2-hour static portion of the checking station, where we were thinking that the mutual aid was still in effect even during the saturation patrol, but apparently that was the challenge, that the traffic offense was committed.
I see what I get it now. I see what you're saying. So it was a mutual aid deal that got it thrown out.
Correct.
I got you. Okay. Yeah. And Justin, you can put your 2 cents in, but I would say, man, just refer back to what that agreement said and the plan to the checking station. If something was authorized, I'm assuming you guys had multiple agencies there, obviously, right?
Several agencies, and the outside agency was the initial stopping officer. And then we took the DWI. So, we had him do the supplement, we did the DWI, and then it was thrown out because of a
jurisdictional deal on his part.
Right.
Gotcha.
Yeah, that's a tough one there. I don't think, that situation doesn't have a whole lot to do with the checking station statute. That's really more about an issue with the mutual aid agreement. I think probably the court was, I understand why the court ruled the way it did, because if your mutual aid agreement was set to expire when the checking station ended, then the moment you guys went from the static checking station to just kind of driving around enforcing Chapter 20, then that's kind of when the mutual aid agreement expired, assuming that's what the mutual aid agreement said. Because once you stop sitting at a checking station, you just start roving around, you're not really doing a checking station anymore, it's just a patrol. And so, I would, exactly what Joe said, I would refer back to the wording of the mutual aid agreement. And, if it said it expired at the end of the checking station, then I think the ruling was correct there. I would say in the future, if you want to do something like that, I would definitely advise, don't just go to a roving situation. Try to just set up, if you're worried about the waves app and everyone's just driving around your checking station, you can't get anybody. Do what happened in that case I was talking about earlier, the one I handled. Instead of going to patrol, just set the checking station up in a separate location, but make sure you actually set up a separate checking station, and make sure that's discussed beforehand. Make that part of the plan, and it's not some kind of random thing you're deciding to do in the middle of it. It's something, if we see the Waze app has flagged our checking station location, we will move, and try, if you can, to come up with a predetermined location. We're going to start here. When we pop up on the Waze app, we're going to move there. When we pop up again, we're going to move over here, something like that. As much as you can do beforehand, and as much documentation of what you're doing and why will go a long way there. And making sure that is sort of mentioned in the mutual aid agreement too, like just the idea that we're going to have a moving checking station and it's going to last for X amount of time, and we're having aid and all these agencies are going to work together, that kind of thing. I think that'll cover you in the future. Does that help, Scott?
Yes, sir. Yes, sir.
Awesome. All right, so unusual circumstances.
Go ahead. We've covered a lot of this, but again, these are things that we're going to have to consider. Go back one. There you go. What if everybody gets busy? We talked about that. At least 2 other circumstances. It kind of goes without saying. Don't take this for granted that everybody there is going to know what to do. And this is mainly for court too, because you're going to get asked. The defense and discovery is going to have the plan, right? And they're going to probably, like I said earlier, have video of what actually goes on at the checking station, whether it be body worn camera or and they can see cars going by not getting checked, or whether it be a dash cam and they can see cars going by not getting checked. And, you know, the plan sits there and it says that, hey, we got to be stopping every vehicle. Well, these are those contingencies, right? We had 5 guys there. I keep referring to the 5 guys there. All 5 of them are writing citations. You know, that's why that supervising officer is important. Not necessarily for him out there doing the checking, but he's actually taking note of these type things that when we do the after actions report, we're going to send to all the people that were there so they can answer this question, right? Again, what if everybody had to use the bathroom in the woods, you know, whatever, right? You know, uncooperative baiting by drivers. This is becoming more and more prevalent. And you can go ahead and go to the next slide, Justin. But talk about this, guys, with your people out there. Know how to handle this guy, right? This guy, if you hadn't experienced him yet, he's coming to a town near you, right? He's coming. You're going to experience this guy very soon. So talk about it so the officers aren't thrown off guard. You can go on the internet, do a Google or YouTube search for officer goes crazy at, you know, checking station, or dumb officer doesn't know his rights or doesn't know the Constitution or something like that, right? And you can watch these videos all day of these people that just go around and they show up to checking stations and they video, you know, just to get reactions and rises out of officers. So, you know, I'm not telling you how to handle him. I'm just telling you, you know that he's coming and have a plan on how to handle him. If you've got reasonable articulable suspicion to ask him out, you know, you've got it. So just know he's coming. So you guys, at the very least, talk about that before it happens and you're caught guard. And there's some of the videos. Everybody's got a camera nowadays. So you guys know that, man. You're one vehicle stop away from being, you know, front page of the news. You know, I was actually TikToked, if you know what that means. I was TikToked on a video on a traffic stop back in December, and it was a Tuesday afternoon at 1:30. Stopped a girl for a seatbelt. By Wednesday morning, unbeknownst to me, I was top 5 on TikTok. All right, and the only reason I knew about it is because I had troopers in other counties calling me, and you know, that's like, you know, what my kids are on, right? The teenagers are on that TikTok stuff, and I was on it, right? So I didn't, you know, obviously I didn't want that to happen that day, but you're just one stop away from any of this crap, you know, so just anticipate it and remain professional. Again, we went over all this. Supervisor rank doesn't matter. Hopefully he's just observing traffic and taking notes. He authorizes and documents any deviations from the original plan. And then to our officers, make sure that they're following the plan. Don't let suspected impaired drivers park their vehicles. How many times have you seen that one, or been in court and heard officers testify to DWI cases where it was a checking station and they testify that the driver rolled up to the checking station, red, bloodshot, glassy eyes, strong odor of alcohol about his breath. What'd you do next? Well, I had him park the vehicle, right? So then you run down the whole nother rabbit hole with the offense. Well, he must not have been that impaired. You let him keep driving, right? So anticipate that, have a plan for that, and just notify a supervisor of any issues, any deviations, especially anything that's going to come up. I've seen this done. We talk about post briefing, after action report. I've seen this done a number of ways. A good rule of thumb or a good practice is shoot an email out a day later, 2 days later, after the checking station with the stats from the checking station. We did this many driver's license violations. We had this many DWIs, made this many arrests, you know, whatever. And then if nothing else, that location from there on out becomes the statistically based location rather than a random, right? If you keep that type of stuff. Number of arrests, any deviations, you know, these are all things that the offense are probably going to attack. You know, again, just remember, they're going to have a video, or assume that they're going to have a video of the whole 2 or 3 hours you were out there. Assume that they got it off the Sheetz gas station that was a block away, and somehow, some way in the 2 years waiting for their case, you know, they obtained that video and they've got the whole thing. Just, you know, assume they're going to have it, man. And anything that comes up, you've got that notated and you attack it and close those doors before they open. And of course, injuries to officers, things like that, you want to document that as well. I think that's it for that.
Mm-hmm.
That's just more or less notes for court. Hopefully you're already bringing, with DWI specifically, you're bringing a big, extensive court file on that particular case. But if it's a DWI or any arrest that stems from a checking station, know that they're going to spend all day attacking that checking station, because if they can get one thing, as you know, fruit of the poisonous tree thrown out on the checking station that you didn't follow, that DWI or that, pound of weed you found in the back seat or whatever, all that stuff's going to get thrown out. So, you need to have copies of all this stuff for 2 years later when it goes to court.
Absolutely. What do officers participate in checking station ADAs who have cases based upon arrest at a checking station have in common? A long day in district court. Yeah, every single one of these cases is going to be litigated backwards and forwards. You got to be ready for that. You got to have all this documentation in place. You're going to have a hearing on a motion to suppress. Motion to suppress is going to be filed in probably every single one of these things, because defense attorneys are absolutely convinced that if they find one little thing, they can, one little issue with the checking station, they can get it thrown out. They tell their clients that, or their clients certainly think that. They can't just stop me and do whatever they want. Whatever, it's that kind of thing. So just be prepared for that. Be prepared at a checking station that you're going to have a long day in court, and doing that documentation up front and making sure you have everything squared away on the day the checking station happened is going to make your days in court way, way easier. So just remember that when you're doing your checking station, don't just think about the checking station that you're conducting tonight or today or whatever. Think about all the time you're going to spend in court for all the cases you have out of that checking station. And remember that it's going to be 2 or 3 times as long if you don't do good documentation. So just make sure you're doing everything right. And yeah, for prosecutors, rules of evidence don't apply at motions to suppress. So if you can have your one officer there to testify, and if other officers saw things and told that officer stuff, that officer can testify about what other officers told him. Other things that would normally be admissible, we can talk about that. So you don't need to call every single officer in for a checking station motion that you might need for the trial proper. So just be aware of that.
Is that the last slide, Justin?
Moving through this last stuff real quick. Okay, yeah, we've already covered that.
Yeah, we've covered all that.
Predetermined start and end time, but you don't really even have to have that for US v. Moore. We've already talked about reasons for why things were selected, location, time span. Time span, same thing with location. If you have a particular start and end time, which you probably should, just be able to articulate why that particular time frame is used. If you notice that there's a particularly large amount of DWIs that you seem to capture after midnight, just be able to say that in court. We typically get our DWIs after midnight. That's when the drugs come out. That's why we set it up after midnight, something like that.
Yeah, and that's another important reason to have an after-action report a day later or 2 days later, or whatever. The supervising officer shoot an email out as to the conclusion and what all happened, because I've seen this hem guys up, and it's just a small technicality, but I've actually seen it in court. They're a trooper or they're an officer. They got drunk very early within the checking station. It started at 10. By 10:08, they had a drunk, so they left with him. They were down at the jail, and they dealt with him for the next 3 hours. They don't really know what time the checking station ended, because they were only there for a few minutes. And I've seen defense go down the rabbit hole. When was the ending time? You're supposed to know the ending time, whatever. And that could have been alleviated just by that officer bringing some kind of after action report that had that documentation on there. Again, that ain't, you're probably not gonna lose your case over something like that, but it just closes that door, so you're not on the stand answering a bunch of questions that are unnecessary.
Yeah, absolutely. That's more stuff for documentation. If you have to change the pattern for letting the vehicles through because traffic backed up or something like that, again, just document it. that's a great thing to, in the email that Joe's talking about for your after action report. Make sure somebody's taking a little note on that when it happens, and make sure that goes out to everybody in the after action report. We changed the pattern at such and such time to let traffic through. We resume stopping all vehicles at X time, something like that. Yeah, it's important stuff to document there.
We went over all that. Yeah. Let me throw out one thing real quick, and we talked about that. I'm going to kind of show this, if you can see this. This is a little small 3x4 inch checkpoint primer that the Conference of DAs puts out. This thing is invaluable, not only to the officers. I'd say it's even more invaluable to the prosecutors. Everything that you could possibly, I mean, case law, it goes through the statute, it goes through each bullet point. It talks about common defenses to checking stations. It's updated as well. This is the latest revision one I think that they have. But get your hands on one of these. If you don't already, I know we give these out at the DWI boot camps that we do throughout the state, throughout the year. But any Conference of DAs course, we usually have these. If you want one, shoot Sarah Garner. If you're familiar with Sarah Garner, shoot her at the conference an email to get one of these. She gave us permission. She said that she'd be glad to send you guys one. So that's an excellent resource to have for checking station cases that you have coming up for court.
Yep, and that's the end of our presentation. Does anybody have any more questions they'd like to pitch our way before we get off? Not really seeing anything.
Joe and Justin, terrific job today. I'm going to stop your screen sharing. This contact information you see on the screen, you will get that in your follow-up email, as well as with, let me remove that, as well as Justin and Joe have agreed that we can share their slides on the Traffic Safety Conference webinar website. So in the follow-up email that you guys will be getting, you'll have their contact information, you'll be and links to the slides, as well as a link to the recording. So let me share my closing slides here then, and then we'll wrap things up for the day. I just wanted to, again, thank everyone for participating today, and especially thanks to Joe and Justin for a great presentation. If you do have some additional questions, as I said, definitely you can follow up with Joe and Justin by email. Before you leave the meeting today, if you'd like to use the Q&A window to share any suggestions that we can help us improve the webinar series, including any future topics you'd like to learn about, please just go ahead and pop those into the Q&A while we wrap up here. Again, as I mentioned, following today's webinar, you're going to receive an email with the recording link, so be sure to watch for that. In that same email is going to include a link if you want to receive a certificate for participation today. You just click on that link, type in your name and email address, and we're going to get a PDF certificate sent to you. Please note, if you happen to be watching this recording right now instead of the live webinar, only those who participated in the live webinar are eligible to receive a certificate. We're not able to award them just for viewing the recording. We invite you to join us for other traffic safety webinars that are planned for the series. Please do visit the website at the link you see on your screen for a list of upcoming webinars. That link again will be in the follow-up email that you receive. At this same website, you'll also find information about the next North Carolina Traffic Safety Conference and Expo. We hope you'll plan to attend that conference, and we invite you to propose topics for presentation. Just follow the link on the website for presentation proposals to submit your ideas. And with that, I'd like to thank you again for participating in today's webinar. And until next time, goodbye for now. Corporate sponsorship for this webinar is provided by Alkalock, North Carolina's preferred provider of ignition interlock technology. Alcolock devices are designed to prevent drunk driving offenses, and in 2020 prevented over 25,000 vehicle starts when alcohol was detected. Alcolock is proud to support ongoing education for law enforcement to help divert the consequences of drinking and drugged driving, and to support all traffic safety professionals dedicated to keeping North Carolina's roads safe for our neighbors and communities. For more information, visit alcolockusa.com.